When we have domestic violence cases, there's the right to assert an order of protection before the court, which is an emergency method that allows a person to go to court from one day to the next, and when they can argue convincingly to the court that they have suffered domestic violence, which doesn't necessarily have to be physical abuse, can be deprivation of an individual, financial deprivation, emotional deprivation, can be harm to a dependent, like an elderly parent, or to the child. Then there is a presumption that the court gives to the petitioner that they should have immediate custody. That is immediate parenting time and parental responsibility. And the court can even order the other side to pay their attorney's fees, to pay temporary support in order to ensure that the petitioner will be protected from further abuse and that they also can protect the child from further abuse in this process. So one of the key factors that the court is going to look to determine who should have the right to custody, that is to say parental responsibility and parenting time, is the mental wherewithal, the mental health of everybody that's involved, of the children and the petitioner respondent, that is to say the mother or father. So if there is a case in which there is a psychopathology, that is to say a mental health disorder that has been diagnosed, that impacts the caring of the child, that impacts the welfare of the child, then indeed that is something that experts can look at. Experts can be called to testify to support one's case before the court in order to restrict or otherwise modify the parenting rights of such a parent. So where we have a case in which there is a history or even one incident of abuse, of mistreatment of a child, we often ask the court for what we call emergency intervention, which is an immediate stepping up before the court, an assignment of an emergency intervener who's a court authorized personnel who's going to do an interview with the child and an interview with the parties and report back to the court on what's going on, if there's any suspicion of abuse. And in such a situation, there often is either temporarily or long-term going to be ordered supervised visitation to ensure as best as possible that there's going to be no further abuse until there's been an opportunity for the court to conduct a more further and comprehensive investigation. So one of the first things that a judge is going to do in a high conflict custody case is to appoint a guardian ad litem. This is an attorney that's going to represent the children in the process. It's also a child's representative is another term that's used. And each of these categories of representatives has a different set of rights and responsibilities in the process. So this attorney is going to often go out and interview the parents, the children. Sometimes there'll even be like a surprise visit that the GAL will do to show up and test the allegations of the other side. Like, let's say one parent says, my ex is doing this with the kids, and the GAL might show up and knock on the door and see if indeed that allegation is accurate or not. And the GAL, guardian ad litem, will report to the judge regarding what's going on. So when there's a lot of contention, when there's high conflict, often the very first thing the judge is going to do is appoint this attorney investigator who's really like an extension of the judge, like the right hand, the judge, who's going to go out and review everything, investigate, and report back to the court so the judge knows exactly what's going on. So in Illinois, the law is that there is no specific age at which a judge is required to ensure exists before a judge can listen to the preference of a child. At any age, the law says the judge can hear the child and take their opinion into consideration. The law also says that at 14, the child is given like a almost adult level preference, or is considered to have enough intelligence and independent thinking to be able to have a weighty opinion on the matter. However, as I mentioned, at any age, the judge can listen to the child, can hear their opinion. The judge even has the right to do what's called an in-camera interview, which is in the judge's chambers, do a private meeting with the child to determine their preferences.